public areas is kind of probably a misnomer because most associations, not all, but most associations do not have, strictly speaking, public areas. They have common element areas that are open to the members of the association. Typically in common elements, those are open to all the members within the association, but not the general public. So not for a person that is, living in a development across the street. It's not part of the same association. But if you're talking about common elements as opposed to public areas, then according to the statute and according to the governing documents, the association is responsible for the maintenance, repair, and replacement of items within the common elements of an association. Then the particular unit owners or homeowners are responsible for anything within their unit as defined in the declaration. And then you have in law, you have a gray area, you have limited common elements, which are ones that not all the members use, but some of the members use more than one member. So you may have a balcony and a railing and a patio that services 5 units. So it's not one particular unit owner, so it's not a boundary that's defined as a unit for one unit owner, but it's not a common element because the 300 people that live in the association don't have access and can't use that balcony. So on limited common elements, the statute is quiet on that or silent on it, and then you go back to the governing documents to see who's responsible for what unlimited area common elements.